for those of you who have never attended an HR Simple webinar before, my name is Amy Tripp. I'm with HR Simple. We work with employment law attorneys all around the country to publish state-specific, easy-to-read human resources manuals. We also just launched a brand new webinar subscription. So we do 2 of these webinars a month. I'll put all of the information in the chat and also in the follow-up email tomorrow, but I will include a 20% discount code so that if you're not subscribed to the webinar subscription, you can sign up. If you have any questions, please feel free to get a hold of me anytime. All my contact information will be in the chat as well. So let's get down to the good stuff. We have a lot to talk about. Tim Davis is here with us to walk us through all this stuff. Tim is a partner with Constangy at the Kansas City, Missouri office.
That is correct.
Okay, awesome. Tim also writes our Missouri and Kansas state-specific human resources manuals for us. I contacted him a couple of weeks ago. We had never done a webinar together. And I said, hey, here's a list of like general topics. Do you feel like you want to cover any of these? And he said, no, I don't want to do that. We have something much bigger to talk about. And it was the day after, I think all of this stuff, the final rule had been issued. So this is all brand new. And Tim is here to talk to us about it. Tim, welcome. Thank you so much for joining us today.
Absolutely, Amy. Thank you for inviting me in the first place. And thank you for the flexibility on the topic. The stuff we're going to talk about is really like nothing I've ever seen in my practice as a labor lawyer. And the changes that are coming and the pace that it's hitting the American workplace is really shocking. So thanks for having me. And I'll just kind of jump right into it then and get going here.
Perfect. And let me know when you are ready for me to come back on for the Q&A.
Absolutely. I'll signal to you.
Cool.
So good afternoon, everyone, or for those of you who might be seeing this someday as a recording. Thanks for joining us all today. Just real quick about who we are. And I usually introduce this at the start so that everybody feels comfortable. We are a labor and employment boutique firm. All we do is labor law, employment law, and issues related to data privacy. And we only do defense work. So if you ask questions, if you have comments you want to make, rest assured we're not looking for a way to sue you based on anything crazy you may be doing, because we are a defense firm only. My name is Tim Davis. I am managing partner at our Kansas City office. This is a little bit about me and what we do and what I do as a lawyer. What we're going to be talking about today is a federal practice. It's a federal law, obviously, for those of you who are not familiar with it. So my practice, quite frankly, even though I'm based out of Kansas City, 90% of what I do is on either the Illinois area, Wisconsin, Michigan, or one of the coasts where labor union issues are much more prevalent. So I do tend to travel a lot. I work with a lot of clients in pretty much almost all the states, with the exception maybe of Hawaii and Alaska. I don't do much work out there. So if it is a federal practice law, we will cover all of the matters here. And I'm going to do some very quick basic stuff here. The focus of our conversation today is on how the NLRB, the National Labor Relations Board, is changing the implementation and application of the National Labor Relations Act in some incredibly dramatic ways that particularly impact on the unionization process under that law. We're not going to spend much time talking in general about the impacts in other areas, how the labor board is changing rules as it relates to collective bargaining or arbitrations. We're really focusing on some stuff that just came out over the last month, dealing with how unions organize, the rules for how they organize, and how the NLRB is attempting to achieve a goal of making a much higher percentage of the American workforce unionized. That's what we're dealing with here. This law, just to go over this little slide we got up here in front, is really the granddaddy of all statutes. It was passed as part of the FDR's New Deal. And the goal of this law was to say, okay, if you've got problems in the workplace, whatever they may be, we're going to give you the right, either in a union setting or in a non-union setting, to bargain and collectively try and make changes in your workplace. So this law protects people that engage in what's called concerted activity. It protects people that engage in union activity. It establishes the process for unionization of the workplace, and then it gives rights about collective bargaining. It is a very broad law that predated virtually every employment law that was ever passed in America. Just to be very quick here, this only applies to private sector employers. This statute does not involve governmental entities. It doesn't in general involve agricultural entities. And it also excludes certain types of employees from coverage. In fact, this law says they're not employees at all. So if you're a supervisor or manager, as those terms are defined under this law, you're excluded regardless of what industry or capacity you're in. So otherwise, it's just for private sector, and that's a key thing that a lot of people tend to forget on this thing. The National Labor Relations Act created a group called the National Labor Relations Board and charged the National Labor Relations Board with interpreting and applying the law. Standard fare for all federal government agencies. But they really put restrictions on the ability to overturn what this agency says. The only courts that can review their decisions are circuit courts of appeals and ultimately perhaps the United States Supreme Court. So what this agency says goes, not just with regard to what Congress said in 1935 when they passed this law, but expanding, modifying, changing the law and how it applies along the way. It is a very broad grant of authority for this agency to interpret it. Unfortunately, what has happened is this agency is a very political body. There are 5 appointees. The sitting president gets to appoint a majority of the board members from his or maybe someday her party. So as the White House goes and how it favors unions or employers, so goes the labor board and so goes the interpretation of the law. And it swings violently back and forth from time to time. I'm a defense side lawyer. All I do is defend employers and their relations with employees and labor unions. So when President Trump was there, those interpretations in his board generally were pro-employer, quite frankly, in almost a crazy way. It was so far right. We've got it swing back left, and now we're dealing with President Biden's board that's firmly in control, and they have completely moved that pendulum back the other direction to where it is just incredibly in favor of labor unions. In fact, President Biden said he wants to be the most pro-labor union president in history. And quite frankly, after you get done with the day, you see he may be succeeding in that goal. So what do they get to do? How does the labor board do it? And this is why so much of what we're going to talk about sneaks up on employers. Most agencies pass their changes or interpretations of the law through a rulemaking process that has to go through the Administrative Procedures Act that require comments and input and feedback and draft rules that then become final rules and takes oftentimes a year to 2 years to get through. This labor board could do it that way, and you'll hear about one thing they did do that way. But this board has the authority to also do it through judicial decisions. So if there is a dispute that is brought to their attention when one party files an unfair labor practice charge, typically it's a union filing against an employer, they can interpret the law in that decision and then apply it across the board to all employers. That can happen quite quickly, and in large part what we're going to be talking about today as it relates to the election process and the unionization process is based on changes that have come about through that. So that is the process we're dealing with here, is an agency that, if it happens to be extreme, can move fairly quickly to make changes in the law, roll them out. And as you'll hear today, in one of the cases that has a huge impact on employers, the labor board today decided that they were going to go back and retroactively apply this change to a case that happened nearly 2 years ago. So that's the kind of challenge we're dealing with here. So here is the current labor board, just for everybody who wants to follow it. We've got a Republican vacant seat. We've got Marvin Kaplan, who was appointed by Republican. And then we've got 3 appointees by President Biden, as I said, that get to have 5-year terms and are very pro-union. They all either had former general counsel experience as the lawyer for a union, or in some of their cases worked for union side labor law firms, kind of my counterparts on the opposite side of the fence. That's the group we're dealing with here. What is their goal? They want to expand employee protections called protected concerted activity, and we'll discuss a little bit about that, but the focus today is on unionization and election process. Overwhelmingly, they want to help unions organize. Labor unions have been in a steady decline since the 70s in the United States, and they want to, and I will predict, will have a dramatic reversal of that trend. I think we're going to see unprecedented union organizing over the next year or two, and possibly over the next 4 or 5 years, depending on the next president. I'm not going to get political on you here, but if there's a change in the White House back to the Republican, a lot of the rules I'm talking about today will likely go away. If there's not, then there would be 4 more years of this kind of unionization assistance. So this is their goal of what they're trying to do. Lest there be any doubt, the current labor board and the current general counsel want to assist unions. I do not believe they're striking a fair and balanced interpretation of the act. Their goal is to assist unions, and they're making steady progress in what they're doing. So let's dig into it a little. I'm going to talk about a weave or a web of things that they have done over the basically last 6 to 9 months, culminating in a decision that was about 3 weeks ago and new rules that are set to come out to significantly drive up unionization rates, unionization efforts, and unionization power in America. 90% of what I'm going to talk about today is not I'm predicting it's going to happen. It already did happen. There are a few things that I will flag as we'll go through that you'll need to keep track and watch for as we get over the next 3, 6, 9 months before the presidential elections, because they haven't happened yet, but there's cases pending so that we know that they're going to. So let me dig into these things so that you guys can see what I'm talking about. As I said, the labor board is focused on 3 things: protected concerted activity, the unionization process, and union leverage in bargaining. These are some of the decisions that they have made very recently. And you can see next to the dates that most of them are coming down in 2023. A few of them you can see are pending matters that we have very little doubt they're going to try and rule a certain way. They just haven't done it yet. I put the case names that are involved in that litigation so you can monitor and kind of hear what's going on. But these are the things they're trying to do. Very strict and broad interpretation of handbooks and procedures and policies that employers have that could impact on protected concerted activity. So the classic case that everybody remembers back in the day was a Boeing decision. Boeing had a policy that banned the use of taking of pictures or videos in the workplace. The labor board back then said, look, Boeing has a legitimate business interest in doing that, even though that could have a negative impact on employees wanting to engage in concerted activity. In that case, taking pictures of videos of their workplace conditions so they could argue that it needs to be changed. The Boeing NLRB said, we are going to give you the right to ban those kind of things so that you can protect your legitimate employer interest, even though there was concerted activity involved. The Stericycle decision overruled that and now says that they're going to take a very broad interpretation of PCA. And if it has a chilling effect on, if an employer policy or procedure has a chilling effect on employees' engagement in PCA, then they're going to ban it. Similarly, very recently, and I'm not going to go into some of these in much detail because, again, our focus today is on elections, in the McLaren decision, which is on appeal right now to the Circuit Court of Appeals, the labor board said you cannot have broad non-disparagement and confidentiality clauses in separation agreements involving employees. Again, remember, that doesn't involve supervisors. They're excluded. Management's excluded. But that overturned the laws that's really existed for 100 years or 80 years. They just completely eviscerated our ability to put certain types of language to keep certain items in a separation agreement confidential and to prevent employees from engaging in disparagement of employers. The PCA and the Miller Plastics, again, I talked a little bit about that. I'm not going to go into that. That's another focus today. Providing compensatory damage for ULPs. I am going to talk a little bit about that. Under this law that we're dealing with today, the labor board has almost always, since the law was passed in 35, held that an employer, if they are accused of a ULP and found guilty, would only be responsible for damages such as back pay, lost wages, lost benefits, etc. Not compensatory damages such as if somebody loses their house because they lost their job, or if they lose their car, or if they lost their health insurance, what might happen to them. The labor board overturned that in a decision called Thrive and said now if an employer engages in ULPs, they can be liable and responsible for these kinds of compensatory damages. That's a little different than our focus today on just the unionization and elections, but it has an impact. Now, if you commit ULPs and you're found to have committed ULP during an election, one of the things, if it involves the termination of an employee or lost wages or damages, they can go after you for more than that. They're trying to chill what an employer may say and do as part of the election process to, again, aid in the unionization effort overall. Similarly, they want to, in the Tesla case that you're seeing right there, and I'll be very brief on this one, Tesla has a rule that says you basically wear company uniforms. Employees wanted to wear union button stickers, et cetera, as part of an organizing drive. Tesla said that's not part of the uniform. The labor board wants to say, hey, they get to wear union stickers and buttons if they want to, because it's part of their protected concerted activity to show their support. And so that case is pending where Tesla lost. And the employees it's on appeal, but the employees there get to wear union supporting materials, hats, button stickers, whatever it may be, while they're operating. The last thing I'm going to talk about that is really kind of part of but not related to is Weingarten issues. Weingarten is a decision that goes back a long time ago that deals with the right of an employee in the unionized setting to have a witness sit in with them, typically a bargaining representative, if they are being interviewed for the purposes of discipline. So you're asking an employee, we're investigating you for potentially committing misconduct. We need to talk to you about that. They would have the right to have a union rep in there with them during that investigatory interview. Well, in the Big Green case, which is pending, the labor board wants to say that that right also exists in a non-union setting. So for all of you that are joining this or watching this as part of in the non-union world, if Big Green goes the way we think it's going to be, you would be in a situation where employees would have the legal right to insist on having a witness sit in on their behalf when you are conducting an interview of them that could potentially lead to discipline based on a situation they're involved with. So watch that Big Green case closely, because it would impact on the 93% of the American workforce that is non-union and give employees the right to have a witness during a investigatory meeting. I'm not going to talk about Banner Estrella. That involves confidentiality of investigations. That one is pending. There is a big deal pending right now, and it's pretty relevant. As we're sitting here delivering this presentation today, the UAW has been on a strike for about 4 days, striking the big three automakers. There has always been a case historically that allowed employers to permanently replace striking employees that are on strike for economic reasons, such as to try and get a better contract. The NLRB wants to say that employers cannot permanently replace employees who are on strike. Now, those of you who are old enough probably remember that that is what President Reagan did with the air traffic controllers way back in the day, and it kind of turbocharged this issue. There's a case called ASARCO Inland Waters that would make permanent replacement strikers illegal. Again, we're focusing on unionization efforts here today, but I will tell you a large part of union campaigns is to advise employees that if they go on strike, if they become a union, and they go on strike because they don't like what they're getting, their employer would have the legal right to permanently replace them. Those are facts we tell employees during an election process. If that law changes, that key fact would be taken away. And in fact, it would be illegal to permanently replace employees who go on strike. And that would then have an impact on unionization as well. As I said, there's a web the NLRB is weaving here that is tightening almost all aspects of a workplace with their absolutely undeniable goal of increasing unionization rates. And we'll get to the specifics on what that is involved with here in these cases. So we're going to be talking about the CMEX decision in some detail in a few minutes. That was just passed just about 3 weeks ago is when that decision kicked in. And it's a huge deal for reasons we'll cover here today. We're also going to talk about the new ambush election rules. The NLRB's goal for many years, at least under President Obama and now under President Biden, is to prevent employers from educating employees. The NLRB does not want employees to make an educated and an informed decision brought about through a period of time where they can gain information, get facts, and then go vote in a confidential situation. The NLRB would love to eliminate that entire process, but they can't totally get rid of it. They're doing their best, but we'll talk about that in a second. But the CMEX decision they just passed, that is a big step in that direction. The ambush election rules, which go into effect, note that date, December 26, 2023, is when they go into effect. The American Steel construction case, which we're going to talk about as part of this tangled web the NLRB is weaving to catch employers in the spider's trap, so to speak. The TriCast decision, which limits what an employer can even say during an election campaign, because the NLRB does not want employees to get information of the impact of unionization in the workplace. Prohibiting employers from engaging in captive audience meetings. We'll talk about that, what that means. In most organizing drives, the key thing employers do is during working time, when employees are gathered together to work, is they pull employees into meetings on paid time. They're not asking them to do it unpaid. And they give informational updates on the unionization process, what it does and does not mean to the union, why the card a union might have persuaded them to sign based on promises and representations the union might have made is not how bargaining works, really to educate people so they can make an informed decision. The NLRB wants to ban those meetings and not even allow employers to do it on their own time when they're paying for it. A significant effort to help unions organize, and there's no other excuse for that. And then Purple Communications is a decision by the NLRB which says employees have the legal right to use employer electronic systems to communicate about things like organizing and forming unions. Even though it's the employer's property, it's their own systems, it's their own processes that they put in place. The NLRB wants to return to an area of the law where under the Garton Truckee decision, which is pending, could come down any time, that would mandate that a private sector employer allow employees to use their electronic systems to organize. And again, it's just another strand in the web that the NLRB is weaving here. So let's dig in and talk about some of these things so you can see in detail what we're trying to focus on and why this is so important for private sector employers right now, given what the NLRB has done. So I'm going to talk first about the Stericycle decision. That is the one that changed the handbook rules here. I'm not going to focus on it much because we're talking about the organization process. But the NLRB in the CMEX case decision that we're getting ready to talk about has said, if an employer commits or has ULPs that occur during the election process, then a union may be able to file a charge, block the vote, and go demand recognition without ever having a vote. You could have illegal things in your handbooks and your materials that are not allowed by the law. And if you're having those during an election, the NLRB could use those to say, look, they've got all these rules that clearly have chilled an employee's ability to vote fairly. They're never going to do it because this employer's committed so many ULPs. So we want you to be able to force to recognize the union without a vote. I kind of put the cart before the horse, but that's why this all comes together. You really need to look at your handbooks, your social media policies, your policies on camera in the workplace, your policies on confidentiality, your culture policies, such as those we shall play nice and be nice to each other in the workplace and shall not make gossip or inappropriate comments. Those can all be illegal such that under the Stericycle decision, such that, as we're focusing on here today, you could have an election overturned and you can be forced to recognize a union based on just written materials you've got that are not legal. So that's the Stericycle decision, why it's important. McLaren I put in here, but again, that's not a focus of what we're talking about today. So I'm going to skip over these two or three that are involved and really get to the one that started this whole show we're dealing with today. And that is a decision called CMEX Construction. CMEX Construction is a case. This is where the NLRB changed the law by virtue of how it ruled in a decision. So if you want more background on this, you can Google CMEX Construction in Constangy, for example, and you'll get the newsletter we put out that covers this in a lot of detail in a narrative fashion. All the other labor law firms did it as well. So if you've got a labor law firm, you work with it already, you can get that from them. I know the Chamber of Commerce, which Amy and HR Simple work with a lot as well, is putting out a lot of great information on the impact that the CMEX Construction case would do. So let me tell you what happened here, because this is a first time in history that this has kind of happened, where the labor law by judicial fiat, the labor board, made an incredible change and placed an incredible burden on the private sector. So here's what it is. If a union wants to organize your workplace, their first step would be to go out and try to get employees to sign union cards. If they can get enough cards signed such that a majority of their employees sign them, whether that is by telling lies about what they may do during bargaining or making promises or giving fake information or just telling an employee, hey, sign this card. It is just to get you more information about the union, or saying whatever they might want to do to pressure or cajole or encourage an employee to sign anything, because there's no oversight. There's no agency or group watching how they get these cards signed. Go out and have a big beer party and let people come to the party and have a few drinks and then sign it. All of that would be okay. So if the union can get a majority of an appropriate unit, which I'll cover in a second, then they can send a letter to you as a private sector employer demanding that you recognize them based on the cards that they've got signed from a majority of employees. You are then on a clock. If you don't respond to that by either recognizing the union if you're so inclined, and I don't think the people on this call would be inclined to do that, or they wouldn't be on this call or on this webinar, I should say. Or if you don't actively go to the labor board and file what's called an RM petition, you have to file this, and you've got to do it within 14 days. You are thereby then deemed to have recognized that union, and you are union after that. So imagine this. You get an unsolicited letter from a union in your email or in the mail, and it says, we hereby demand recognition for all the employees at your location, 1221 Smith Street, wherever you live. We want you to recognize this. You've got 14 days to file that petition with the labor board. You can do it electronically. You can do it online. You're probably going to want to work with your lawyers or your labor people you work with to do it, but you are on the clock. So for the first time that I'm aware of in history, the labor board is saying, if you get a letter from a union, you have to initiate this election process to have an election in your own workplace. And if you miss that 14-day requirement, you're barred and you are now union. That is an amazing challenge for a lot of employers. What if something gets caught in their email screen because it comes in as a PDF? What if it gets sent to a manager who's on vacation? What if it's a smaller or remote location where the people aren't trained and don't know what to do with it and just throw the letter away? There's all kinds of challenges related to how do we know that letter is received at a certain time, handled appropriately. It is going to be a nightmare for employers all over the country. And so this is the big challenge that kind of started when Amy and I were talking about what might be an important thing for non-union employers to be thinking about. This topic is very timely. As we sit here today, it is September, just to be clear, the 17th, and this has only happened about 3 weeks ago. That's how recent this is. To close the loop on this thing, the labor board is trying to make this retroactive to cases that occurred before. And that's what the next part of this would be. If you do what you need and go file that petition, or if the union doesn't wait the 14 days and files its own petition, because it could still that, and a petition is what they do to file for an election, by the way. If you start the election process and you are accused of committing ULPs, the union can then stop the vote and go to the labor board and say, hey, they're committing ULPs. There's no way we can win this election. Order them to bargain with us without ever there being a vote. If they win that ULP charge that they're filed, or if they wait till after an election and you as the employer win it, they can try and overturn the vote. They've got two chances here. So the bottom line is your elections, once they present you with that letter, demand letter for recognition, have to be absolutely clean. If they're not, they can block the right to vote, or if they lost, they can overturn the right to vote and go in and demand recognition. Again, this is not how the law has ever existed since 1935. So I want to drive that point home to everybody. This decision changed the entire unionization process in America in a way that it's never existed since 1935. So it is a very, very big deal for all of you. Immediate action items coming out of this decision is you've got to notify your entire management team that if they get one of these letters sometime, you're on a 14-day clock and you as an organization are going to have to respond. Typically, that's going to mean filing that RM petition that I mentioned. Obviously, we need to do some preventative stuff because it's going to be so much easier to unionize your workplaces than ever before. Train your management on good supervisory skills so that you're harder to target for and organize in the first place. Train your management team on early warning signs so you can know if this card signing is going on so that you can prepare and maybe educate and inform employees about why signing that card is not good for anyone in advance so that they don't get enough to make this demand for recognition or they don't get enough to go forward with an election. In my experience, employees that understand what union card means and what unionization means, truthfully and honestly, they don't do it. They don't go down that route. Train management on the law. Here's a very, very challenging aspect. For those of you who may have been through a union organizing campaign in the past, or if you haven't, supervisors are usually a vital part of that now. But in the world we live now under CMEX, where if the supervisor says or does something wrong, the employer can be forced to bargain with the union without ever the employees having a legal chance to vote. It's risky to even use supervisors as part of your campaign. That is part of the NLRB's goal here. Make no doubt about it. Their goal is to prevent us from educating our employees. They do not want that to happen. And they think by, hey, if we give them one ULP and they can be forced to recognize the union, they'll call the supervisors off. That's a strategy decision you'd have to make if you're faced with this union organizing effort. If you are going to go forward and fight utilizing your management team and supervisors, you got to train them about the law. Tips and flow training is what we typically call that. But that will be an important part of any union campaign you do. As I said earlier, review your handbook and materials to make sure you don't have something that's not legal there that could also be used as part of an effort to overturn or block an election, because they can go back to look at your papers as well. Harden your target. Do whatever you can to do routine wage and benefit surveys so that you can see if you're remaining competitive in your area, your industry, your occupations, whatever it may be, so that, again, people are less likely to maybe reach out thinking a union would get them more money. Review potential campaign issues. And again, this program we're doing is an hour today. We don't have time to cover all the stuff that we're talking about here, but I do have a very detailed checklist at the end that you can be using that kind of goes over this slide and a little bit more. What's an appropriate unit? What kind of micro units, which we're going to talk about next? Do you have joint employers issue with a temporary agency or somebody you contract with that works on your site? Do you have a single site, or do you have multiple sites, or like a restaurant chain where you've got sites spread all around, or are you just a manufacturing site that's one place? Who is a supervisor under the law? That's called the 211 section of the statute. Those kind of things that you can do in advance to see what we can do to prepare, reduce our risks, and potentially make sure we can stretch out a campaign so we've got time to educate and inform employees about what this all works. Preparing your initial campaign materials. I've worked with a lot of employers over the years where we do initial drafts of a speech to employees about why we don't think it's in their best interest to sign a card. We've done orientation videos where we write scripts and hire actors and they show a movie about that. All those kind of things, if you consider yourself to be in a high-risk industry or high-risk area or something like that, are important to start looking at. So I'm going to pause right there. I see I've got one thing in the chat. That is something that Amy. I'll keep going then, Amy.
Okay.
All right. So we're going to keep moving here. And as I mentioned to Amy, when she said, hey, would you talk about something like this? It is this decision that made me think we need something different and broader. And this is something that our law firm, and I know law firms, and I know chambers, and I know, great HR groups like HR Simple are doing to educate people on, because it's changed the law for private sector employers in a way that has never existed. So that's why we're doing this. The second phase of this, by the way, is something I mentioned just a second ago called micro units. That is the process whereby which a union doesn't attempt to organize an entire large facility, perhaps, but tries to get a smaller unit within that facility if it doesn't think it could win a bigger election involving everybody. On your screen right now are some examples of how some of these works, where a union tried to organize just the tool and die employees at a Nissan assembly plant, or tried to just organize the maintenance employees at a Boeing, where there were 7,000 employees, or the maintenance people in an IKEA distribution center. These are examples of where a union can try to carve an employer up into smaller bite-sized pieces if it's not getting enough union support in an effort at a bigger organization. The American Steel construction case, which came about in 2023, as you can see, gave the unions a lot more ability to do that and to decide what targeted group they might go after if they cannot get an entire workplace or work site. So when we talked about up here under the CMEX that they've got to go after an appropriate unit to sign cards, it doesn't always necessarily have to be an entire location if they don't think they can organize an entire location. It can be just the maintenance department. It could be just the warehouse department. Or it could just be the production facilities or just the quality employees. It can kind of carve employers up and go after them in ways that are easier for them to try and get a foothold or toe in the door. So that's what American Steel Construction, which just happened this year, allowed them to do. So you've got CMEX where they can get cards and demand recognition, 14-day trap. They can go after smaller units under the American Steel. Under the other decisions, they can go after employer handbooks and materials if they're not legal. What they're also looking to do, and I want to make this one clear as part of a campaign, this is still pending. The full labor board has not ruled that mandatory captive audience meetings or group meetings are illegal. Current general counsel of the labor board is pursuing cases that would allow the labor board to make that decision. They could come out at any day. I'll be honest with you right now. I'm talking to all my clients when we get union organizing. we are making an evaluation of what do we do with regard to captive audience meetings, because we're quite confident, like the labor board is prone to do, if they do make these illegals, they would try to make it retroactive. So what we're doing right now could in the future be illegal, even though it's currently legal in this crazy world of the NLRB. So you will need to do that. If you get caught up in union organizing, have to have that conversation with your labor council. And what, quite frankly, we are doing is whenever we're going to bring employees together for a meeting right now, we are saying things like, this is an entirely voluntary meeting. If you do not want to stay, you will not be in any way retaliated against or punished for leaving, nor can we or will we reward you with anything or favoritism or any kind of special treatment if you choose to stay. It is entirely your voluntary decision. And then we move on with the meeting. And if people choose to leave, then we really are going to have to decide what you do. You're going to need to have that conversation now with your council, unless and until this thing comes about and we know where it's going. So again, this is part of another strand in the web I've been talking about, where they want to put you in a situation where you got to respond within 14 days, decide exactly what unit they want to target, prohibit you from holding meetings to talk with your employees and educate them about the unionization process. And then the last strand of this whole web that I want to talk about, or the second last one, is a decision that occurred last year where the union and the labor board want to prohibit us as employers from saying to employees, if you become union, you can no longer deal directly or talk directly with us as your employer. You have to go through your union. I paraphrase that a little bit, but in reality, the gist of every campaign, and where I've found the most, in my experience of doing several hundred elections over my career, the most impactful thing you can say to an employee during the unionization process is the impact being in the union would change on your culture. You no longer have us sitting together trying to work out solutions. You are now generally going to be going through a union to sit down and engage in this kind of process, whether it's bargaining or grievances, and working together in a culture where you are part of a team and you really truly are all for one and one for all, goes away with unions. You pick your path, and that's what I usually say. There's two paths, and this vote you would have, you decide, are you going the union path, which leads to this, or do you want to go down this path, which leads to our ability to try and work together and see if we can address our challenges? Through the TriCast decision, they're trying to limit that message to a certain extent and help unions organize by taking that tool away from us. So that decision happened late last year, and is another strand in the labor board's unionization effort web. Now I'm going to get to the thing that we highlighted when we were talking about all of this. And let me see if I can make it all dark in here. Maybe I can. This is the new ambush election rule. Everything I've talked about so far on this program have been changes that the NLRB made to help unions through its adjudication or case process. The ambush election process is something they did through the rulemaking process. And that's why we get advance notice. That's why we know, as you can see on the screen, that these rules that I'm about to talk about do not become effective until December 26th. They've already been announced. It's not speculative. It is going to happen. We have a date, and this is Merry Christmas to everyone. This is the present you're getting from the labor board. So it's effective December 26, 2023. What does it do? As I've talked about before, historically, years ago, going back to the 80s and 90s, employees were given 10 weeks, basically, to, once the union filed a petition with the labor board to conduct an election, you usually had about 70 days, about 10 weeks to decide whether or not you wanted to be a union. You could get information, employers could have meetings, unions could have meetings. You just had time to really consider this very serious and make a measured decision, and then go into a confidential ballot box or voting area and decide, do you want to be represented by the Teamsters Union or whatever union it may be, yes or no. Under President Clinton, that was shortened to basically 42 days. And then under President Obama, it was shortened down to 21 days. Under President Trump, it was extended back out to closer to 25 to 42 days. The goal of the current labor board is to go back to the 3-week election period. So if you can imagine a scenario where your employees are so unhappy for whatever reason that they want to go to the cost and the risk of potentially considering unionization, trying to change their attitudes or get them information so they can understand the full process and what it does and does not mean, in 21 days in that kind of heightened, intense environment is very difficult. And that is the labor board's goal here, to get employees to make decisions without education, without information, and when they're in an emotional situation, perhaps, so that they're much more inclined to bring in a union. Make no doubt about it, this goal of shortening the election process is designed solely to achieve higher unionization rates. So under these ambush election rules, an election will generally, absent some really unique legal issue or challenge, have to occur within 21 days of the date a petition is filed. As part of that, they are banning our ability as an employer to have a hearing before most of these elections to decide who is an appropriate person that should or should not be voting. Rather, they're deferring those decisions on what's the appropriate unit, whether somebody should be allowed to vote or not, till after the election. So many times employees now will be voting without even knowing what group would be voting to be part of their bargaining unit, because some people that they think might be in it might not, or some people that they think might not might be. So they're never going to have any assurances when they go in there to vote, okay, who will be on my side in the bargaining unit represented by the union, because the labor board isn't even going to decide that till after the vote. It's an inherently unfair process where employees can't make an educated and informed decision. But again, that's not the goal. The goal is to not make an educated and informed decision. So they're going back to these kind of unit issues will be decided afterwards. And anybody some employer might wants to challenge, they have to challenge during the voting process. Those ballots would go in a special envelope. And then depending on how the board rules after the vote, they would be opened or thrown away. That's the process we're going back to. So 21 days, hearings about who's in the appropriate unit are generally deferred till after the vote. And we're returning to a process, an early requirement to post notices and an early requirement to give a bunch of information to the labor board and the unions immediately after a petition is filed. So if you get a petition for an election after December 26th, you'll have 2 days basically to get this poster up on your bulletin boards and in certain circumstances emailed to all employees, notifying them that this has happened. You will then have a very, very short clock as well to turn over a whole bunch of voter information, identifying information, who's in the unit, names, addresses, mobile numbers, personal email addresses, those kinds of things, so that the labor board can contact them, or actually so the union can contact them, the labor board would not, and be able to start their campaign with direct solicitation of employees at home or by electronically. That is what this new ambush election rule will provide December 26th. Now, we're laying out, and our firm is putting together a detailed timeline so you can kind of see it more in a checklist, perhaps, form of these new rules. But the bottom line is, this is the new process we're dealing with. You get a demand letter under CMEX. The union may wait 14 days to see if you fall for the new trap the NLRB has set for private employers. And that is if you do not file your RM petition. They might not do that. They might want to go ahead and file their own petition, so that then you've only got 21 days to respond, rather than waiting for 14 to see you file it and then having 21 days. Well, they get to choose, really, we don't as employers. So if they catch you in the new board trap under CMEX, you're a union without a vote. If you or the union file a petition, sorry, somebody wasn't in there. If you or the labor board file a petition, whether we file an RM petition or the union files an RC petition for election, and any ULPs are committed during that process, the union can stop the election and demand bargaining, file a ULP and tell the board, make them bargain, we didn't get a fair election, or they can wait till after the election occurs and then if they lose, try and get it overturned then. Either way, during that process, we are going to be severely restricted in having captive audience meetings, in having what we can say to our employees, in deciding, having any real say in who's in the bargaining unit that they're after. All of those have been taken away from us in these decisions that happened over the last few weeks, or a few months, I should say. So that is the whole web that we are dealing with now under the new board unionization process that this labor board really kickstarted over the last 6 months. So that is our challenge we're dealing with. The result, as you've probably seen and felt, is, at least for my career, I started practicing law in 1992, is dramatic increase in the number of union campaigns, high profile ones, Starbucks, Trader Joe's, Apple, REI, Amazon, all these kind of high, well-known companies have been experiencing a lot of union organizing. We're seeing unions really try to capitalize on the coming out of COVID and all the challenges our society's had over the last 3 years in wage inequity to drive issues on why employees should join and form unions because of those challenges. And the labor board is supporting that by some rulings they've had saying that this kind of activity can be protected, concerted. The biggest issue I've seen and the challenges I've faced, quite frankly, with my clients and our labor relations efforts is issues related to wage inequity. That's becoming a societal issue that a lot of people are pointing out. And the new generation of employees that are coming into most workplaces are, I want things now. Every time I got done with a soccer match when I was a kid, I used to get a medal. Where's my medal for coming to work? I deserve to be paid a lot more like all these influencers get just for being on TikTok. And so what you're paying me to make your stuff or to provide your service isn't enough. I want things now and I want it more. That is really a real challenge with today's workforce, and the unions are capitalizing on that. They now have been handed the platform they need and the process they need from the National Labor Relations Board to organize, and they're really utilizing it to capitalize on the right message now for the new generation of the American workforce. So it is very much a challenge that people are struggling with and dealing with in the new modern workplace. So to recap where we are now and make sure we're kind of staying on time here, and to be able to go over in some summary fashion the materials I wanted to provide everybody today. This is a very complex law that can change rapidly and unfortunately even change retroactively, as we're seeing with the CMEX decision that was decided 3 weeks ago, the labor board trying to apply it to a dispute, an election that occurred in January of 2022, almost 2 years ago. So it's very complex. This is an area where if you get a demand letter, you're on the clock, you need to seek counsel and be prepared, ready for as quickly as you can. The process that you're going to be going through has very detailed timetables. The CMEX decision puts you on a 14-day clock. The ambush election rule is going to require you to do certain things within as little as 2 days. And then after that, 7 days, and then have a vote within 21 days. So you're going to have these very specific requirements if you ever get involved in this election process, not to mention the very complex rules about what you can say to your employees during an election, how you can say it to it, whether you can mandate it meetings or not. All of those are changing and in flux. So if you went through a campaign a year ago or 5 years ago, it's very, very different now, and you're going to have to revise what you do. Go back and look at your handbooks, your separation agreements, your non-competes. Don't give anybody any low-hanging fruit to say you violated the law. There's a lot of issues out there right now with handbooks that just have stuff in them that are not legal because they chill an employee's ability to engage in concerted activity, whether it's just bonding together with other employees to complain about wages or because they think they might want to unionize their workplace. Prepare for that CMEX trap. If you've got multiple locations, for example, or if you've got various people in your organization that get notices or that a union could send it to, make sure people need to be aware. And you can do this through a short email. I've drafted some for clients to pass out to their HR and team. All it needs to say is, if you're receiving any formal invoices or not invoices, excuse me, formal notices from any governmental agency, or you receive any letter from a labor union or a group of employees that demands recognition, you need to notify human resources or some designated person immediately. And if you don't hear back from that person that they received it, you need to follow up with a phone call so that we don't have the vacation issues. We don't have issues getting caught in email, whatever. This is really a trap that you can be non-union 1 week and 2 weeks later, if you haven't done what you need to, you're union in that group the union demanded. It is that simple and that fast, and people can get caught up in it. If you're in a hot industry or a hot area, healthcare, for example, has been targeted for unionization all over the place. Restaurants are being targeted. Logistics and warehouses are being targeted. Some places in parts of the country, we're seeing more in manufacturing. But if you think you're in a hot area or hot industry, prepare for this activity in advance, because if you can slow things down and prevent a union from ever getting those cards signed, then you can avoid having to go through a vote. You can avoid the potential NLRB CMEX trap that they've set. in many instances, as we're talking about, what a supervisor says and does could bind you as an employer. So you need to think in advance, what are we going to do with our supervisors? If we're going to include them in any messages, or if we just think that they're going to be exposed to organizing activity, we've got to train them to make sure they don't do something wrong. Because the comments that they make or things they say could end up us being in a CMEX situation, or where they've done something wrong during a normal election. So consider how we're going to handle supervisors. That's a strategy decision and a legal decision you'll need to make up for. Non-compliance, unfortunately, in this legal world that we are as labor lawyers, is not usually about dollars. Most of my clients say, you know, this is about my business. I built this from scratch, or I put this together with my family member, or I'm representing shareholders, or whatever the case may be. Unionization impacts on how you operate and manage your business for as long as you're union. So it's something that is a big issue for a lot of employers. And if you do things correctly, you can achieve your goals. So that is what I wanted to cover today in terms of the basic stuff. And I'm not quite done yet, but I'm gonna get ready to throw it back to Amy to see if we have any questions. I did a lot of doom and gloom, I think, today with people saying, man, this is going to be a nightmare. But I don't like ending that way. I don't like just making everybody think that the sky is falling. So at the end of my stuff here, I would commit, if you've got questions that come up after with, shoot me an email or send me a text. That's my mobile number, or give me a call, I guess. I won't throw a bill at you, and Amy's not going to throw a bill at you either for any kind of follow-up calls. We want to make sure you're getting this information. That's part of HR Simple's goal, and that's part of my goal in doing this. I'm not going to throw you a bill for this kind of thing. But give me a call so we can answer your questions. And in addition to that, at the end of this thing, I put together, for those of you, when you get this slide deck, kind of the 7-step program that I think you all should be thinking about to harden yourself as a target. And I'm going to scan through it quick. Policies and stuff you should review that impact on unionization, benchmarking things like wage and benefits, and preparing your message for how you would explain to employees why you're able to do or not able to do what you can't do. Doing internal survey to see what employees are happy or not happy about. All of those kind of things are critical. Evaluating yourself as an organization. How would you organize yourself? When I do union avoidance training, the most fun that we have is when I spend an hour talking about the things that cause unionization. And then as part of a way to gather information on issues we might be having, I say to them, okay, now you're an organizer for the UAW. How are you going to organize your own employees? And it's kind of amazing how they kind of week through, well, I would start with this guy because he's always complaining. Here's the issues we've got. And you can kind of almost see how you would be targeted by asking your own supervisors as part of the training. How would you do it yourself? I found it to be a pretty effective tool in getting that information. So study yourself, do those kind of things. Do training as necessary. And again, that's a strategic decision in the world we're living in, where you got to decide how you're going to utilize supervisors, because it is not just an easy thing that you want to do. You are going to educate them to make sure they don't break the law, but you might not utilize as many members of your management team to conduct your campaign. Do your risk response protocols. What are you going to do with various areas? How are we going to see where we are now? Okay, nobody's after us. How do we take precaution? Okay, we're starting to get complaints about a lot of issues, but we aren't hearing union talk. What are we going to do to address those issues before it becomes union talk? Okay, now our issues are union talk and we're at Code Orange. How are we going to specifically educate our employees about what union cards mean? And then Code Red. Now we've either got a demand for recognition, or we've got a petition that's been filed, or we've got really aggressive card signing. What are we going to do? Kind of think through as a team how you would address that and train to that and prepare for that so that you can cover it. A lot of clients prepare their initial materials in advance. If we hear about union activity, we want to get this letter out to employees explaining what cards are. Do we want to use videos? Do we want to have handouts? What can we do to educate our workforce to hopefully get them to where they realize that union isn't good for them and they don't want to sign a card? Those are the 7-step programs that we want to encourage and that are provided in your materials that Amy is going to be forwarding to everybody, I think, or I think they may be available, Amy. I don't know how you're going to do it. But I think the goal of this program was to do a rapid education on the changes that have come about over the last 4 weeks. By the way, I should have said this. The ambush election rules were just announced 3 weeks ago. So those are brand new. CMEX was just 3 weeks ago, brand new. Most of what you've seen is in the last 3 to 6 months. So it's all brand new. but it has a dramatic impact and dramatic change on unionization potential and issues you would face as an employer in the private sector workplace. Now, that was a long hour, and I tried to do it fast, Amy, to cover everything I could, but I'm about out of breath. So
you did an amazing job. When you we're talking through the 7 steps and you're like, we take an hour just to like, go back and forth and how we would unionize and organize everybody. I'm like, oh, wow, we could go on for a long time about this, but that was a great, first look at all of these changes and what's going on. I have some questions that were submitted while you were talking.
Okay, fire away. I will stay as long as you need.
Awesome. Okay, we really appreciate this. So we got this a couple times and a couple of different ways. So somebody in the chat says, is there a minimum size for unionization? If we have multiple locations and one has only 5 employees, can that single location unionize?
Excellent question. That is a fantastic question. And the answer under this law is there has to be at least 2 employees. And the reason is, if it's only 1 employee, there's really not concerted action, it's just individual action. But if there's 2 or more employees at a work site, that work site can organize it. And I've got a lot of contracts in the funeral home industry. I got contracts where the Teamsters represent 2 funeral directors at a nursing, at a funeral home. So yes, the short answer to your question is, if you are a covered employer under this law, they could organize locations that even have as few as 2 employees in them. Not 1, they have to have at least 2.
And by covered, you mean a private sector employer.
You got to be a private sector employer engaged in commerce under the National Labor Relations Act. That's why it's a federal law, because it applies across the whole country. And there is a very, very broad definition of what is commerce that generally involves the amount of money you receive, the amount of things you receive that have been shipped across state lines, whether your business does stuff across state boundaries, et cetera. Overwhelmingly, most all employers are covered by that because the thresholds are so low. But if you're really a small employer, that is something you would always want to ask your counsel about. If you get this kind of activity, are we even covered? You're probably going to be, but you should still ask that question just to be sure. So great question.
Okay. Yes. And then the second part of their question was, if we have multiple locations and one has only 5 employees, can that single location unionize? And we got something very similar, that if one of our locations unionizes, does that affect any of our other locations?
Yeah.
Same sort of deal.
Again, great questions. The first part is the NLRB uses what they call the single site presumption. And that is that each individual location where you have employees would be considered to be the appropriate site for unionization, not all of them put together. Now, the single site presumption would break down if, for example, you're interchanging and people are rotating amongst all the different employees at different times, and then they all get put together. But in general, if you've got 10 locations and they're separate, they're ran separately and employees don't move back and forth, they would only organize, and each location would get a vote for themselves, whether they want to be union. If a location does decide to be union, it does not affect the other ones. They would remain non-union unless they then went through the same process. So the long answer or short answer to your question is, only those sites that vote or that bring a union in through CMEX are union. It doesn't affect the others. And typically the sites would be separated unless you're interchanging and commingling employees from various places.
But I would have to assume that there's more of a likelihood that another location might at least look into it or vote or something because one did.
Amy, that's a great point. And the best example of it is Starbucks. Starbucks, since they started trying to organize Starbucks over the last 3 years, has had approximately 300 elections, all at different stores and all over the country. There's not been one big vote for all of Starbucks. It is 200 stores out of total, I think about 15,000, I think is what Starbucks has. So it sounds like a bigger deal than it really is. But each one of those Starbucks stores, whether it's 10 employees or 30, they're all voting separately in their own election. And then they bargain their own contract separately. So Starbucks will ultimately, if they ever get agreements, will have 300 different contracts, a different contract for each location.
Wow, that sounds so very complicated.
It is a pain, yes. I'm sure Starbucks isn't real happy about it, but it's better than having all 15,000 employees or locations, whatever it is. So
Yeah, that's a good point. Does working from home affect this in any way? Or
yeah, it can, because for example, if you've got a group of employees operating call centers now, a lot of times people are spread out doing it from home.
yeah,
They wouldn't be their own separate unit in their home. It would generally be all of the place that they report into would be considered the unit. So
got it.
yeah, there has been a whole kind of weird thing going on now with the whole, so many people working from home these days that the labor board is dealing with. That's correct.
I bet. Okay, moving on. So it says, if we know our employees have been discussing potentially forming a union, but nothing has been submitted yet, what do you recommend as our next steps to be prepared?
Well, typically, what we do here, and I just got rid of everything here. Let me go back to this. This protocol that you're looking at, I think I got it on the screen. I kind of screwed it up. Most of my clients, if their goal is to remain non-union, if they start hearing about discontent, employees are unhappy because they're not paid right, they would go in there and try and address the issues and either explain why, no, here's why it's fair, or whatever, or address it if it's not fair, and try to do it if they can afford to, of course. Once that goes from an issue of we're unhappy about something to union organizing, we typically do things like preparing, where is it? These kinds of things. We send a letter to employees saying we kind of help the employer draft a letter to say, here's what the unionization is about. Here's what the card they might be asking you to sign would say. Here's why we don't think it's in your best interest. So if you really want to remain non-union, there's union organizing going on and card signing going on, you've got to address it, or they're just going to hear the union side of the story, and it will usually continue to proceed and progress to the point where you then do get into the formal legal stuff. There is absolutely nothing wrong with starting to communicate with your employees. If you hear of union organizing, it is absolutely legal and appropriate. You have to make sure what you say is legal, of course. But if your goal is to remain non-union, we always say this a lot. You can't lose an election you don't have. If they never get enough cards signed, you don't have the risk of CMEX demand, and you don't have a vote. And if you educate and inform them about what this does and does not really mean, and you can avoid it, then that's your best bet in every instance, is get these kind of letters about the card and that kind of stuff out.
Okay. Just because I don't know a whole bunch about this, do you need a certain percentages of your employees to sign the cards? Is that?
Yeah. Great question, Amy. Yes. The way it works is, for them to go to the labor board to request a vote, they've got to have 30% of an appropriate unit. So let's use Starbucks because we've been talking about them. Let's say there's 24 people at Starbucks at a store. If they wanted to go ask for a vote, they'd have to have, what is 30% of 24? Is that 7, I think? They'd have to have 7. 8 would clearly be enough because that's 33%. They'd have to have 7 people sign a card. So it's not a majority. It's just 30% that you have to request an election.
Gotcha. Okay, that's very good to know. Okay, this is, you touched on this a little bit, but I'm going to ask the question just because they submitted it. We're thinking of implementing surveys about employee satisfaction, including salary, benefits, mental health, etc., without obviously mentioning this is so our employees don't want to unionize. Do you see any potential pitfalls regarding what you talked about today?
Again, you guys are good. Great questions.
Yeah, they are.
In general, if you're trying to do surveys because there's union organizing going on, that could be a solicitation that is not allowed once we know union organizing is going on. We can't do that kind of thing. If, however, it's just a general thing you're doing now because you want to get information and there's no union organizing going on, I love those things if they're done by somebody who knows how to do those surveys and do them appropriately. However, this is one thing I always advise people is careful what you ask for. Because if you ask for those kind of questions and you do a survey and employees are really unhappy and they point out all these things they want changed or whatever the case may be, and you don't do anything, then that will backfire. And you'll get employees saying, we told you exactly what was wrong. You did nothing. Why should we believe you? We got to go outside and get somebody else to help us. We're going to go get a union to bargain for us. So the potential pitfalls are if you don't take them seriously and respond as appropriately as you can. In many instances, somebody might say, we're not paid right. We're not paid fairly. We need more money. And whether it's the product or services or whether the state of your business is, you can't pay more. Many instances, the answer isn't just to give them what they're asking for, but it may be to communicate. Guys, we would love to pay more, but here's why we can't. Our customers have driven down our margins. Our industry is whatever challenges we got. But explaining it to people so that they can understand where you are might be enough in many instances, but not responding at all is where you run into the biggest challenges.
Sure. I think at least just having them know you're listening, paying attention, and that you just care. I think it's a lot for some people.
Amy, I've been through, I lost track after somewhere around 300 elections in my career.
Oh, wow.
Every time the issues and stuff is different. But what isn't different is you lose elections or you get union activity based on issues with two words: communication. You're not communicating, you're not educating and informing them, and they don't understand what's going on at work or whatever, and trust. If you don't keep their trust, you're going to lose. If you don't keep their trust, they're going to be more interested in reaching out to unions. So if you are communicating effectively and earning employees' trust, this issue doesn't come up as often. So if you don't remember anything out of the program today, union avoidance or labor relations 101 is based on trust and communication.
Trust and communication. It makes perfect sense. But yeah, okay, that is so interesting. Okay, I think that we've got one more question, I believe. Just want to make sure. Two quick ones. It says you mentioned captive audience meetings possibly being illegal. Does that apply only to meetings about unions?
Yes.
Okay. Yes,
they're not banning or in any way changing your right as management to do whatever else you might want to do in meetings. It would just involve messages about unions that they're banning. And some of you might be thinking, as you should be, how can the federal government, a 5 government agency, of which only 3 are saying we got to do this because they've got 3 majority. Everything I've talked about today was done by 3 government bureaucrats. How can 3 government bureaucrats tell us what we can and cannot say to our employees that way? Tell us what we've got to do to respond if we get a demand letter. This isn't a new law. This isn't a new statute. This law has been around since 1935. But all of a sudden, we got 3 governmental bureaucrats saying exactly what we can and cannot say. How does that not violate the First Amendment? Because the federal government is telling private sectors what we can and cannot say. That's why I think there's going to be challenges to this stuff in the courts more as we go along. But that's what we're dealing with here. 3 unelected governmental bureaucrats having the biggest impact on the private sector that's occurred in 40, 50 years. It's that big of a deal.
That is wild. Okay. And then the last one here, it's I think they're just looking for a little clarification about who those letters will be coming from that they should keep their eye out for.
Yeah, great question. Normally they will be coming from the labor union, whatever union it is. So if the Teamsters are trying to organize you, or the UAW or the SEIU, it'll usually come on an official union letterhead. I've got 2 of these already since this thing was passed just weeks ago for clients. Both of them were email. And I think that's by design because an email, you know exactly what date and time that was sent and received.
Sure.
And so the unions can prove when the 14-day clock. So in my experience, it is a scanned document that came by email. In one instance, the client's screen got it because they don't accept PDF documents somehow as part of their screening process.
Yeah.
And in that instance, the union sent them another one saying, please check your screens because we just sent you demand in case. So they're trying to do everything they can to show that 14 days thing should start. So it will be on typically a letterhead, and I think it'll come by email normally. It might come in the mail sometimes if it's not email.
Do they have to send it to a specific person, like a specific role or like owner, presidency, or can they just send it to anybody?
Again, if we went through the normal rulemaking process where they give us specific guidance that's been thought through, we get that. This case does not say who it has to go to. It would have to be some level of management or HR. It couldn't be to another employee or somebody who doesn't have management responsibilities. We just don't know how far down the ladder they could go. Is it a frontline supervisor? Maybe in a small company, but probably not in a big, couple thousand employees. You can't send it to Joe on the street and expect it. Typically, in my experience so far, it's gone to HR.
Okay.
They send it to human resources, and then they do follow that up. In both the cases I've got, they followed it up immediately with a phone call too. Because
Okay.
they want to be able to prove that that 14-day clock started.
Yeah, they know
We'll see how they
exactly
play it
what they have
out.
to do.
All the unions are going to end up doing it different in all the places. Some of them will just send it and then be quiet and hope you fall for the 14-day trap.
Right.
Others will maybe try and give you more heads up, so that they can prove that they should start the clock. And right now, we're only 3 weeks into this, so I have no idea how all the different unions are going to do it all around the country.
There's so many
No, the
possibilities.
trap is set. How they're going to spring it in with every employer is going to vary all across the board.
Yeah. Wow. This is the lot. I know there are a whole bunch of other changes going on with other issues too. So I really appreciate you coming on and doing this and offering, to answer any questions and stuff through phone calls. And I'll make sure that I put all that info in the follow-up emails that go out tomorrow with all this stuff. But Tim, we really appreciate it. Thank you so much. And, if something else changes and something big happens, hopefully we'll have you on to do a follow-up or something, but maybe we can talk about a different topic when you come back next.
Absolutely. I am happy to do that, Amy. And thanks for your group for sponsoring this, because we are trying to push this out through every association and organization we can, because too many employers are going to get trapped. And HR Simple, you guys, I think, do a great job of getting the stuff out to people. And your partnership with the chambers is just awesome. So thanks for what you guys are doing there.
Yeah, absolutely. Right back at you, Tim. All right, everybody. Thank you all for coming. I really appreciate everybody being here, and have a great day. Bye-bye.
Take care.